the Court of Appeals, Division 1 is now in session.
Please be seated.
Hang on just a second. Counsel, what does that say? My plaque? Okay. It says Judge Andrew W. Gould on the back of it. So Andy's another guy.
Thank you all for being here. I think we have our young slates in the proper places. We're here in our case when CV140543 Trask versus Handley. Each side will have 30 minutes, or I'm sorry, we'll have 20 minutes to present their argument. Apparently, you may reserve any time that you want for rebuttal, but you need to keep track of that yourself. For that purpose, there's a clock on the podium, and we have a clock here, so we can keep track of that for ourselves. We're recording the argument, so please identify yourself and your client when you begin. In a few days, the argument will be on YouTube, so you can be instant YouTube stars. We've read the briefs and the record, and we've conferenced the case, so we're familiar with the facts and the law. So just begin your argument. Counsel, you may begin.
May it please the court, my name is Stanley David Murray, and I'm the attorney for the appellant Susan Marie Trask, who was the petitioner in the lower court proceedings. Normally when I do oral argument, I skip going over the facts, but I'd like the court to focus on the relevant facts for this appeal. We're talking about interpretation of a decree. We don't need to worry about what that money was used for. We don't need to worry about accounting as to how those monies were spent. We need to look at the decree to see how the debts were divided amongst the parties. And this decree was quite clear. Husband was to pay the second mortgage. $104,000, $102,000, I can't remember the exact figure, but it's right there in the debts that were listed.
Didn't that principally presume that that husband would qualify to refinance the property and end up with both the first and second wrapped into one, probably?
Yes, sir. He had the option to refinance the property if he wanted to, but if he couldn't refinance it, then he was to transfer title to my client and still be responsible for that second mortgage because there was no release upon transfer of the title.
I thought that the house had to be sold if he couldn't refinance. Have I misunderstood?
Well, wife had the option. Wife had the option to sell or keep it, and if she kept it, then he had to transfer title. And so that's what she did. She exercised that option under the decree to keep the property because she couldn't sell it, to tell you the truth. It was underwater. It was negative equity.
So she got to keep the house and he had to pay the mortgage?
He still had to pay 100% of the mortgage because that mortgage was used for his benefit. It was to build the studio, to equip it, to furnish it, to custom design it, all for his benefit. As he admitted, it was his baby. My client had no interest in it whatsoever. In fact, she had to remove it after he left because she couldn't rent it out to anybody because of the homeowners associations and the city of Chandler rules that require somebody to live there to operate the business.
So he had to pay for the improvements that he really didn't get to enjoy.
Well, they became fixtures. They became part of the house. And so because he was operating his studio on the premises, he got the benefit of having that studio built for him while he operated that business. Yes, sir. The best scenario would have been for him to refinance and assume the first and second mortgages, obviously, but that didn't happen. And my client didn't want to get stuck holding the bag, having to pay for this $102,000 mortgage which went into his business and went into his studio when she had no use for it whatsoever. It's almost like a school loan situation, if I could draw an analogy. Usually the spouse who gets the school loan and gets the college degree as a result, at the time of divorce, gets stuck with that debt because it benefited them solely, even though it was a community obligation incurred during the marriage. Same thing here. The only difference is we have it secured by a mortgage. And a lot of people automatically think, well, the mortgage goes with the house because, after all, that's what it's for. It's a lien against the house. But this debt was solely incurred for husband's benefit, and that's why my client drafted that decree to make sure he remained responsible for that regardless of the situation. The issue comes down to, once he did transfer the title, did he have a right to be released from that obligation to pay the second mortgage? And that issue, I don't think, was approached by the court in the second trial. It was clearly identified in the first trial. The court said, no, I'm going to interpret this decree as it's written. I don't care what the intent of the parties was. I don't care what the negotiations were. I'm going to read this decree and interpret it as written. So the judge did get it right the first time, and he also found that the second mortgage was used for the husband's benefit, so it was only fair that he should pay for that. Somehow we got a complete reversal in that motion for new trial that was granted. And so my first problem was granting that motion for new trial was inappropriate to start with when that motion for new trial wasn't properly filed. As we pointed out in our brief, the respondent did not cite the particular rule that he was going under to seek that motion for new trial. You have to identify each of those 6 paragraphs, if they apply to your case, as to the basis for your motion. The evidence that they said did not support the ruling did support the ruling. The relevant evidence, not all the evidence, but the relevant evidence, the decree, the fact that he signed a deed over to the house, and the fact that he stopped making payments. That's all the judge needed to know in interpreting and enforcing the decree. So there wasn't any newly discovered evidence or any evidence that did not fit the judgment that was entered. The court did not state the grounds for granting the motion. It stated the issues. It said we're going to have a retrial on the attorney's fees and on the second mortgage, but it didn't state the grounds as to why it was entering this motion for new trial. Now, my opponent points out that this was waived because it wasn't raised at trial, but that ruling on the motion for new trial was never made final. So we believe we still have the right to attack that because it wasn't final until that final judgment was entered in June of 2014, I believe it was. The law is quite clear, and I'd cite quite often to that Zale case, which says we're going to read that decree as it's written. We're not going to put terms in there that are based on the parties' negotiations. We don't care about the parties' intent. We don't care about the parole evidence, any outside evidence. We look to the decree. But yet Judge Dunn imposed the wrong standard in his review on that second trial. He said, I need to know what the party's intent was. I'm going to interpret this decree according to the party's intent.
Don't you look at the record of the case, too, to understand the decree?
The record?
So I understand that you wouldn't use the Taylor kind of analysis to interpret a decree like you would a contract, but you still got to look at what happened before the decree to understand what the decree did.
No, sir, not when you have a decree that's, or an agreement that's merged into the decree. This was an oral agreement, of course. But even if you had a written agreement that was merged into the decree.
But so you understand what a decree, the judgment in a case is? You can't look at the pleadings to understand what the judgment is doing? It seems to me you've got to look at the record of the case that ends up in the judgment.
And that's fine, Your Honor. Yes, you can look at the record, but you can't consider the party's intent. You can't consider negotiations.
But you still have got to understand the case to understand the decree.
Certainly. And that's I'm saying that Judge Dunn used the wrong standard because he's looking at the intent, not the record. The Cohen case is also on point because that involved a separation agreement that was merged into the decree. And instead of saying we look to contract law principles to interpret the decree, the court emphatically stated we're going to look to the 4 corners of the document and look at what the statutory duty of the court is in interpreting an ambiguous term. No ambiguous terms here. There was nothing in the agreement, or excuse me, in the decree that said he gets released from his obligation to pay the second mortgage. I guess he would have liked to have that language in there, and he probably should have asked for it before he signed the consent decree and agreed that it was fair and equitable. but it's too late now to raise that issue. The decree stands as written, and that's why we're asking the court to enforce it as such. There was a lot of evidence that was presented, building statements, receipts, et cetera, how that money was spent. But I don't think the court needs to concern itself with that, again, because I'm emphasizing the decree's language. It's not ambiguous, so there's no need for the court to go to any other sources to interpret this decree. But if the court has any questions about that, I could answer those as they arise. It's all about finality. We can't keep challenging these decrees when evidence gets stale, memories get hazy. We need finality when it comes to debts and property. Sure, spousal maintenance, child support, statutes specifically authorize modifications of those. But the trial court cannot modify property or debt division unless there's grounds under state law, which is the Rule 85 analogy or analysis, or if it's an omitted asset under Dressler versus Morrison. The court needs to enforce it. Finality, get this decree enforced, husband pays for that second mortgage. On the attorney's fees issue, the court will note that all Judge Dunn considered was the initial application for attorney's fees and not a China doll affidavit for the second trial. He didn't say he was denying attorney's fees for the second trial, but in order for him to exercise his discretion, he needs to know all the attorney's fees that were incurred before he can determine if $2,500 is a reasonable amount. Our opinion, of course, is that with the $11,000 in attorney's fees that was submitted to him, $2,500 is too low, but again, that's his discretion. But he didn't make a full, complete review of the record without that China doll affidavit for the additional attorney's fees that were incurred. And so we're asking this court to vacate that on the grounds that it doesn't consider all of the evidence in making that ruling. Also, financial disparity. The court said there's no change in financial disparity, but remember that wife is now paying that second mortgage ever since September of 2012. Her income level has gone down as a result, whereas the husband's has gone up because he's not paying that. And I think it was about $800 to $1,000 a month, but I'm not
But she has a house.
Sorry?
She has a house now.
He has a house.
She does.
Well, he said he bought it with 2 other people, so I don't think he's paying that much.
I'm sorry, her house.
She has her house.
Yes.
Right. But she's paying a debt that he was supposed to pay, so it's a debt that she now has to assume when there was no reason for her to do that. Again, because the decree said he is solely responsible for that debt. So her financial situation has been hurt as a result. So we're asking the court to vacate that award of attorney's fees and remand for a proper determination of both the first and the second trial when attorney's fees are to be considered. And unless the court has any other questions, I'll save my 5 minutes, if I may, for rebuttal.
Thank you. Counsel?
Good morning. Police's Court. My name's Jason Castle, and I'm representing the respondent, the husband in this matter, Wade Hadley, or Handley. I've got 5 points I want to cover. However, I'll briefly describe those and then go over those, and then I want to address some of the points raised by counsel. First, I believe wife's argument is inconsistent. And what I mean by that is counsel set forth some facts for the court to consider. However, I think it's a kind of a bait and switch, if you will. He tells you that the second mortgage is the only thing that matters. Well, that's not really true, because if you go back and you actually look at the decree, not only is husband being stuck with the second, he's also being stuck with half of the first. So he's paying half of the first for her as well, according to their interpretation. Now, the court in the first trial awarded the first mortgage to her, but they're not challenging that. They didn't challenge, oh, wait, the court already modified the decree in their view. They're saying, oh, we'll accept that modification, but we're not going to accept the second modification. So there's some inconsistency there that I don't think is consistent with the ruling. The other point that I'd like to make is equity and an equitable distribution. According to 25-318, the court is required to make an equitable distribution of the property. According to wife's reading, she gets the house, which the only evidence that was presented was an appraisal done of $580,000. So you have a house that has $580,000. You have a first mortgage of roughly $410,000, I believe. I apologize for not knowing the exact amount. And then you have another 105 on the second, which comes out to roughly 515,000. So there's roughly about $70,000 of equity there. So wife's taking, in essence, a $580,000 home as her property, and then husband's taking almost all of the debt. In addition to that, she took all of the other property. She got to keep all of her retirement. She got to keep all of the personal property, which we calculated to be roughly about $42,000.
Well, counsel, it sounds like what Mr. Murray has said and would say is that your client made a bad deal and should have thought about that before signing the consent decree.
And, Your Honor, I'm not going to disagree with either of you in that regard. This is a terrible deal. It's so bad, in fact, it's against the law. My argument is that 25318 requires the court to make an equitable distribution. The reason the court is reviewing it is to
even if the consent decree is not ambiguous, the court still has an obligation to make that equitable application.
Absolutely. I do believe that. In fact, I think 25318 mandates that the court make an equitable distribution of the property and debt.
So, in the end, it doesn't matter what the parties voluntarily agree to. If it's inequitable, the court can fix it.
Well, I don't think the court did need to fix it. I think the court's review, when it reviewed the decree originally, assumed the same thing that I assumed when I first read it, which is the party taking the house takes the debt. And then, as you pointed out, the house would be sold and then the proceeds would be divided equally. And so, in the event the wife took it. So, from the court's perspective, wife was taking the debt. Well, originally the intent of the party was that husband would take the house along with all the debt, and as wife testified, the intent was he would pay off all of the debt. And then at that point, she wouldn't have any liability, and they would go on their merry way. Unfortunately, because of economic situations, my client was not able to refinance, and wife decided to exercise her right to keep the house rather than sell it. And as a result, that creates an unequitable result in this case that I believe the court is required to rectify. And I don't believe the court initially intended for the decree for there to be an unequitable distribution of property and assets. The next point I'd like to raise is that wife never addressed that argument, the fact of the equity, and also the presumption against wife. Wife drafted this decree, and husband at the time, as evident in the trial, was not, we did not argue that he was unable to enter the agreement, but he had some other issues, as Judge Thompson pointed out. He had some other issues going on. He ultimately went into psychiatric for depression and suicide attempt 2 weeks after he signed the decree. We
would only be using this interpretive tool if we were interpreting an agreement.
Correct.
We wouldn't interpret. The drafter of the decree is nominally the judge, right? So
ultimately,
we're not going to consider who the judge drafted it. So we're not going to construe it against the wife because she drafted the initial agreement.
And the court wouldn't have, from the judge's perspective, wouldn't have created an equitable distribution as part of our argument. And so that wasn't the intent of the order when it was signed. The final thing that counsel raised, 2 points actually. He made a statement, he made an analogy of the student loan. I don't think that's an accurate analogy at all. With a student loan, the party who received the education gets to take that with them. In this case, after wife took over the house, she destroyed the studio. He wasn't able to have access to the studio, and she essentially reduced the value of the home, turning roughly 500 square feet of livable space, usable space, into a garage, a two-car garage. And so unlike a student loan where you get to continue utilizing the benefit that you received, the education, with the studio, he didn't get any utilization of it. In fact, she destroyed it. The last thing on attorney fees, counsel expressed that the court didn't consider all of the facts, when in fact the court heard testimony that husband was on welfare for part of the pending litigation, and that the court ultimately concluded that there hadn't been a change in economic situation for either of them. Counsel argued that there had been because she increased her bills. Increasing her bills isn't changing her income, it's just reallocating where those funds are going. And so I disagree that her paying the second somehow was a reduction of her income. It may have been a reduction in where she could allocate her resources, but it doesn't change the income that she was receiving. Going back to the inconsistent, if wife is correct that the husband is responsible in reality, because you're not going to change anything, for all of the first and all of the second, how can they make the argument that he's only responsible for the second if in fact the decree only awarded her 50% of the first mortgage? I think that that's inconsistent and not at all what the parties intended nor what the court intended, as evident by the approval of the modification that occurred. And in regards to the intent, as Exhibit 31 in the trial pointed out, it violates the property allocation, would completely violate an equitable distribution in that husband would essentially be receiving roughly $380,000 in debt, almost $400,000 actually, and wife would be receiving somewhere in excess of $500,000 in assets. That's not equitable in any stretch of the imagination. Wife also asserted, and she started off today saying that the facts don't matter, but then she asserts that the second mortgage was used solely to build this studio, and that's justification for him being awarded the second mortgage. However, as you go back and you look at the trial transcript from the second trial, that's not true at all. The studio was essentially, as the debt was incurred, and I believe that's wife's Exhibit 7, clearly illustrates that the expenses were incurred prior to the date the second mortgage was obtained, which was January 8th. And so you can't argue that the second mortgage, which was taken after the debt was incurred, was used for that purpose.
Wasn't that second mortgage obtained then to retire that debt that was incurred to build the studio?
There was never any evidence to prove that or show that at all. And so I know wife made the argument of that she was utilizing funds from a prior home. However, the reality is if she was purchasing things prior to their marriage, that would be considered a gift and not a community property debt. So I don't think that wife's argument is accurate there either. In regards to making the decree consistent, if it was intended that wife would just take the home and husband would take all of the debt, why would they divide if the house is sold, why would they divide the net proceeds? They wouldn't. If it was intended for wife to take all of the assets out of it, she would have just taken all the proceeds from the sale. But that's not what the decree says. The decree says that if the home is sold, that all of the debt would be paid, and by all the debt I mean the first and the second mortgages, and then the net proceeds would be divided equally between the parties. To read that otherwise would be inconsistent with the idea that the party who took the property would also take the debt. And going back to, just for the court's record, I made reference to Exhibit 7 in the trial, showing the expenses that occurred prior to the second mortgage being taken, and that was Exhibit 21 that shows that it was taken on January 18th of 2008. The only debt that wife did take as part of the decree was the Chase credit card. During the second trial, she admitted that that was actually a separate debt that was used to pay for her son's student loan. And that's on page 45 of the trial transcript, line 20 through page 46, line 18. Also in the trial, she clearly identifies that she took all of the property, and that the husband took essentially about $600-700 in property, which amounted to some speakers, an older laptop, computer, but the rest of the household furnishings and such were hers. Not counting the house, wife took a positive value of assets of $151,122, and husband took a positive or a negative allocation of $42,041 because he paid off all the other debt, the credit cards and such that they had, and wife admitted that in the trial as well. Wife argued that part of her retirement was her sole and separate property, however, didn't provide any evidence to support that. During the trial, she admitted that she contributed to her retirement during the marriage, and however, never provided any evidence as to what portion of that may have been her separate property. And under Cooper v. Cooper, the Supreme Court has said that unless the wife or the party shows it's separate, it's presumed to be community when you have commingled funds. We believe that the appropriate resolution would be to have wife be responsible for the first and second mortgage and for the property to be sold and the proceeds divided. However, that wasn't originally asked for, and so at this point we're asking that wife be awarded the first and second mortgage and the parties walk away. Regarding the issue of attorney fees, we do not believe that the court abused its discretion. The court heard the evidence. The court made a finding that the party situations had not changed and entered a ruling of attorney fees of $2,500, which was paid by my client. Does the panel have any questions?
No. Thank you, counsel.
Thank you.
Counsel.
Thank you.
What is this stuff?
I don't want to interrupt.
Oh, I'm sorry, counsel, please.
Well, I guess I do get to talk about the evidence after all. Some of the numbers that Mr. Castle came up with are not supported by the record. He talks about the equity in the house. My client testified it was underwater. Even his client testified it had negative equity. So I don't think the court can find much substantiation for the numbers that he's coming up with on the equity value. He says that the husband only got $700 worth of equipment, but he fails to mention the studio equipment and the business that husband got to keep that wasn't divided up. It was given to husband. The community paid for that too, because when they sold the first house, you would recall from the testimony, they had also had a second mortgage then that was used to buy equipment and furnishings that they were going to use for their studio to be built in the new home. Which brings me to the next point. How could they build the studio until they bought the Nash residence, the new home? Sure, the receipts that we had were only from 2007, but husband refused to provide the documents that my client needed to show the expenses in 2008. The loan was taken out in January of 2008, and the studio was completed in March of 2008, was her testimony. She also testified about how husband, when he moved all his equipment out of the studio, took all the files and all the receipts with him. She had been the treasurer, but he maintained those records. He kept those in his possession. There was a dispute in the first trial about a motion to compel for discovery of those receipts, but they never were produced. So the evidence of any 2008 expenses weren't presented, but the testimony certainly was. And so the construction could only occur in 2008, and that's what part of that $102,000 was used for. And the equipment that he did get, he talks about how the equipment deteriorates in value. Why did he take it then? He takes it up to his new studio in Las Vegas and uses it, so it's got some value to him too. So it was more than just $700 that he got. He's talking about my client destroying the livable space of the studio. Well, the studio was not livable, and in fact, it deteriorated the value of the house, that it had to be removed. She talked to a real estate agent and said, you've got to turn this back into a garage because nobody's going to buy a house with a studio that doesn't have any equipment in it. So she had to incur another $5,000 in expenses just to get that fixed up. How long can you keep raising this equitable defense argument and reviewing a decree? At the time the decree is entered, the court makes a finding that it's fair and equitable under 25-318. If you don't like that determination, you either appeal, or you file a motion for new trial, or you file a Rule 85 motion. Time limits expire, though, and here we are 2 or 3 years later, 3 or 4 years later, and they're still raising this argument whether it's fair and equitable. That cannot be raised at this point in time. The only thing that can be raised is if the decree is ambiguous, then under Cohen versus Fry, the court has an opportunity to look to see if, under the whole circumstances, it is fair and equitable. But you can't keep raising it, especially at this late stage. And again, as I said, the deal that he got wasn't that terrible. He got all the equipment and the business, and he's doing fine up in Vegas, apparently. Mr. Castle started out with the inconsistent positions we took about the first mortgage and how a husband was supposed to pay 50% on the first mortgage. Well, that wasn't modified by the court. That was modified by my client. She was able to refinance an interest-only mortgage that was of no benefit to her and change it into a better mortgage for her to assume, which she did, and told them that's what she was doing in the first trial. And then in the second trial, again, she agreed that she would take over that first mortgage. It's something she did voluntarily, and for them to complain about that doesn't seem very consistent to me because he's off the hook for 50% of that first mortgage. So if the parties want to modify the terms, no problem with that. But they don't want to modify the second mortgage, and the decree says husband has to pay it. The court should enforce it. That's all I have, unless the court has any questions. I just want to cover those points.
No.
Thank you, Your Honor.
We thank you for your argument. We'll take this matter under advisement and will issue a decision in due course, and I think we'll stand at recess. Thank you.